I've been asked to talk on the theme of whether what's sometimes called clinical education can serve as a means of radicalizing the students who experience it. And there are a hell of a lot of contentious themes and terms in even what I've just said. But I'm going to actually just deal firstly with what I mean by clinical education, which I think in this context means the attempt to provide, in a systematic manner, opportunities for students to practice law in some form or another, on behalf of clients, quite obviously, and of course under proper supervision, as an integral part of their legal education. And it might just be worth starting by trying to understand why. What is it, as it were, that's specific to legal education that makes the experience of practice or opening up the opportunities for practice a potentially radicalizing experience? Well, there may be all sorts of reasons, but I'm going to suggest three. First of all, I think historical accident, not entirely accident perhaps, but there is an association, clear association, with the development of clinical education initially in law schools in this country, with the introduction of the new law schools in the 1960s, and particularly those at Kent and Warwick, and come back and say a bit about that a bit later. Actually, as part of that, and more so perhaps at Warwick, but also at Kent, within the opened curricula that those law schools attempted to provide for students, which involved large emphases on engagement with social sciences, particularly sociology, to some extent economic and social history. There was a focus on what is sometimes called the American realist movement. Within the American realist movement and the law schools which had been set up in the United States in the 50s and 60s, which in one way or another claimed a sort of heritage from the realist movement, there was a focus on the need to engage with legal practice as an integral part of legal education and engage critically with legal practice. And as part of that, many of those law schools, if not all of them, established forms of law clinic as integral parts of the curriculum they offered their JD students, the equivalent of our LLB students. And there was within the new law schools, particularly, as I say, Kent and Warwick, in this country, a very strong influence from the realist movement and its combination of engaging with practice, with what's sometimes called rule skepticism, that is a skepticism about how you could see law and the practice of law, indeed the study of law, as mainly, or even more than marginally, about the study of rules, as had traditionally been the case. There was a view that the realists could provide a very good framework and US law schools could provide a very good framework for the development of legal education in this country, and clinics were part of that. And that, to that extent, I think it was seen as a sort of radicalizing potential. Although here I'm talking more about the radicalization of law schools rather than the students who came from them. The third reason, I think, why in one way or another clinical education has been seen to have a potential to produce radical students and beyond that radical practitioners was because of the fact that, and it is a fact that, the client base for university law clinics is essentially those from the least privileged and most disempowered sections of society. If you're running a law clinic, just as if you're running a legal aid practice as a solicitor, you are necessarily going to engage with some of the most fundamental issues of disempowerment and inequality in any society, because those are the clients you're serving. So I think for those reasons, to an extent that's much greater in law than it would be in, say, engineering or veterinary science or dentistry or medicine, where clinical experiences seem to be absolutely essential as part of the education process, the provision of a clinical experience for law students was seen to be potentially radicalizing one. There is one final sort of contextual point that I would want to make here, which I think is really very important to understand some of the differences, I think, between legal education and the education for other professions, particularly in this country. Almost every other profession I can think of, as I said earlier, requires some form of engagement with practice as an integral part of the qualification process, as part of the full-time education that an intending practitioner, as a dentist or doctor or vet or architect indeed, requires. That's not been the case with law. In this country particularly, we've had a view which is that the training part of qualification is something which is best left to practitioners and to what's sometimes called the training or professional stage. That is, after you've completed your formal education, that's the stuff of the universities or the professional law schools. Once you've done that, then you can start on the practical end of things. And therefore, it's never been seen as a necessity or even as desirable that the full-time education stages of qualification involve practice. Part of that is a traditional contempt. It seems often a contempt that practitioners have for academics and full-time educators. Something which I think is mutual shared contempt. But part of it is just the way in which legal education has evolved from its 19th century, particularly 19th century origins, which involved very strong emphasis on apprenticeship. Now, it's interesting, in the United States, of course, they do not have, nor have, to my knowledge, have they ever had an apprenticeship stage. So students do their 4 years in college, 3 years in law school, and then go straight into practice. And therefore, one of the impetuses behind the establishment of clinics in the United States was very simply the need to get some form of practical training into that process. And the only period it could happen is in the 3 years of the JD program in law schools. So even in the United States, the development of clinics was seen to be a sort of practical as much as a sort of radicalizing necessity, and probably even more so. But that certainly identifies perhaps why in this country in particular there is a choice, there was a choice about how much practice you put into the full-time education, particularly at the academic stage, that's the LLB stage, and therefore I think a choice about what you saw its role to be. Because you knew, among other things, that some of the more detailed areas of practical training would be left to the training contract, it used to be called articles or pupillage, depending on whether a student was going on to be a barrister, a solicitor or a barrister. So that's, I think, some of the background to what I wanted to say. I think it's basically, yes, there is a potential, particularly in clinical education in this country, for the reason I've just given, for it to be seen as a radicalizing experience, for it to be used to introduce students to radical ideas, particularly about the nature of legal practice and the role of lawyers, to an extent which is certainly greater than its equivalent form of education in other professions here, or indeed to an extent compared with the position in the United States. And I think if I could just, I'm very wary about putting autobiography into presentations of this kind, but thinking about what I was going to say for purposes of this this brief contribution to the conference, it occurred to me that my own experience might be worth talking about, because I went purposely. In fact, I chose to do my law degree at one of those new universities, Kent, coming in 1967, where I was exposed, and I'm very grateful that I was exposed to a very, very, sometimes somewhat chaotic, but extremely engaging legal education. for 3 years, where, among other things, there was a huge emphasis on reading the American realist movement, on studying disciplines other than law, and within law, looking at some of the more radical, socially focused, socially based theories about the nature of law, as compared, say, to the study of traditional black letter law, which I would have been doing in almost every other law school in the country at that time, or within jurisprudence, to the study of some of the sort of highly dry, pretty uninteresting areas of legal philosophy, which then formed the core of the jurisprudence syllabus at that time. So I came out of Kent having had this extremely, by standards of the day anyway, very radical legal education, and by chance got my first job working in what became in fact an embryonic community law centre in South London. And I was aware from day one of how little my, albeit extremely radical, theorized legal education, how little it had done to prepare me to meet the needs of the clients that I was meeting in that law centre. In fact, a project within a CAB in South London. And I thought, hang on, there's something wrong here, because I may have all the theories in the world about why people, my clients, are facing the social and economic and political disadvantages that heaven knows they were certainly facing, and had the legal needs that they had as a result in part of that. But I felt myself, somewhat paradoxically, disempowered to do anything for them until I had been sort of just prepared, trained, given some tools to work with, including knowledge of some of the key areas of law relevant to their needs, including social security law, housing law, consumer protection law, and so on, some immigration. And it made me reflect, therefore, on what had been missing from my legal education up to that point. And indeed, what would have been missing had I then gone on, which I didn't do at that stage, to complete my education, either by doing what were then called bar finals, or I was going to become a solicitor law society finals, because certainly none of those gaps would have been filled in by the content of those courses at that time. And so I began thinking a lot about what kind of legal education might be necessary to fill those gaps. And by chance, a close friend, my tutor at Kent, a man called Adrian Taylor, at that time was beginning to think about the needs for, in the same way, and to some extent the same reasons, for clinical education. And one of the reasons why I became and have remained very, very strongly committed to the provision of clinical experience within law degree programs or the next stage professional education programs is that I do not believe that you can give students an appreciation of both the potential and the limits of law and legal services to meet the needs of the most disempowered and disadvantaged in society, unless they've had an opportunity within their legal educations, integral to their legal education, to engage with not just the issues in theory, but some of the realities of the clients and servicing those clients as well. I think it's worth emphasizing that it was very much with quite a lot of those issues in mind that both the Kent Law Clinic, started by Adrian Taylor in 1972 or 3, and very quickly after that, soon after that, the Warwick clinical program, it was very much with those sort of concerns in mind that those clinics were established. Both of them, in different ways, has to be said, were founded on the idea that the role of a law clinic in legal education wasn't to prepare you to be a sort of technically better lawyer, but per se, but to give you an idea of what lawyering could achieve for, particularly, as I say, for the most disadvantaged and disempowered. And I think it's not, therefore, coincidence by any means that students from those days have, I suspect, I'm pretty sure this, disproportionately been found in what one might nowadays call legal aid practices, the law centre movement, and so on, and in university teaching, which one way or another continues to focus on those issues. I mention that because for about 20 years from the mid-70s, Kent and Warwick were the only law schools in this country which had clinical programs. And both, as I say, established on some pretty firm, if contentious, but firm pedagogic principles. But from around the mid to late 1990s, partly encouraged by something called the Enterprise in Higher Education program, which was had been sort of an inspiration of, I think, Mrs. Thatcher originally. More and more law schools were enabled to start law clinics, and did so. And certainly under the Attorney Generalship of Lord Goldsmith in the first Labour government, there was a very strong push to encourage law schools to establish law clinics if they could possibly do so. Now, the interesting thing from my point of view and point of view of this, the theme I'm talking about in this talk, is I think it's fair to say that a lot of those clinics were established on rather different pedagogic principles from those which had informed Kent and Warwick. Because in most respects, they saw the role of the clinic in what I'm going to call rather traditional professional education terms. That's to say, in terms of enabling students to develop skills, either generic or specialist legal skills, as part of their full-time education. There's no question that there could be great value in that, partly because that had been itself seen as a desirable objective from the late 1990s as a result of increasing evidence of the variable quality of legal practice, both in solicitors, among solicitors and barristers, and the rather haphazard approach to the development of practical skills and legal education provided by training contracts and pupillage. And it was therefore seen, I think quite understandably, as a potential way of addressing those issues, that a certain element of what I've termed clinical experience was integrated into the undergraduate curriculum and also the curriculum for the professional stages for the bar and the solicitor's professions. Now, I think what that indicates very clearly, perhaps everything I've said indicates very clearly, is that for the reasons I've talked about earlier, clinical education can be a radicalizing experience, can prepare students for engaging with practice on behalf of disadvantaged and disempowered groups when they qualify, can encourage and inspire them to do that, can give them the tools to provide effective services to those clients, but it need not necessarily do so.